on the issues raised by the claimant in his final written address. The defendant reiterated his stance that the issue of fair hearing was raised for the first time during cross-examination by the claimant, and in rebuttal, stated that the rules of natural justice does not apply in the case of suspension, that the processes that require giving fair hearing is usually activated by a query when summary dismissal is required, that it is even the law as established in the case of Yusuf versus VON Limited, reported in 1996, 7 Nigeria Weekly Law Report, part 6463, page 746, Court of Appeal, that suspension cannot be questioned on the ground that it could not be done unless the employee is given notice of the charge and the opportunity to defend himself. That is, the rules of natural justice do not apply in cases of suspension. Furthermore, Learned Defense Counsel submitted that while the claimant tendered the letter of employment and letter of suspension, he failed to plead or tender the staff handbook, which contains the terms and conditions of service relevant to his reliefs 2 and 3. That it is a well-established legal principle that a party seeking declaratory reliefs must prove entitlement based on the strength of his own case, not on any admission or weakness of the defense. The case of Esowe and another resource, Ogiemware, reported in 2018, LPELR 46341, Supreme Court. And that's the end of the submissions. So, the courts, having regards to the facts and circumstances of the suit, the process is filed by the parties hearing, the evidence adduced, and the submissions of counsel. The court has distilled the sole issue below for determination, and that is to say, whether, in view of the evidence adduced by the claimant, he has been able to discharge the burden of proof required by law to entitle him to the grants of his relief. The claimant's suit is founded on the of employment with the defendant, and in civil cases, the burden of proof lies who asserts and adduce credible evidence to adduce credible, cogent, and sufficient evidence to establish what he asserts to be in existence. See the case of Section 131 of the Evidence Act 2011. The claimant has to prove his case on the balance of probabilities or on the preponderance of evidence by producing credible evidence, documentary and oral, to establish his claims. See Obey versus MTN Nigeria Communication Limited 2021, 18 Nigeria Weekly Law Report, part 1809, page 415. Learned counsel to both defendant and claimant raised some preliminary issues. Whilst counsel objects to Exhibit 3 and 6, being the judgment 2018 and the collective bargain agreement dated 5th December 2019, respectively. Claimant counsel objects to Exhibit 3, that is letter of termination dated 12th July 2019. Both counsel were advised to address the issues in their final written addresses. However, the defense counsel seemed to have jettisoned his objection. The claimant counsel raised a preliminary issue of law as touching the admissibility of Exhibit D3, being a photocopy of the letter of termination. Relevancy governs the admissibility of evidence, but there are certain class of evidence that are absolutely inadmissible by virtue of some statutory provisions, while others are made admissible under certain conditions. Versus State versus Labo. Reported in 2023, 1490 law report, part 1903, page 31. Documentary evidence is the best form of evidence. See Asset Management Nominees Limited versus Fort Hill 2029 Nigeria Weekly Law Report, part 1889, page 23. The claimant's objection on the admissibility of Exhibit D3 appears to this court to be one that seems to address the weight to be attached to Exhibit 3 and not particularly its admissibility. It's relevant, it was pleaded, and it is generally admissible, given compliance with Section 84 of the Evidence Act as amended. It complies with the criteria for the admissibility of documents during trial. Diverse Asset Management Limited versus Roma Bank PLC. 2023, Nigeria Weekly Law Report, part 1897, page 121. The probative value or weight to be attached to a document is distinct from the issue of admissibility of the said document. On condition precedent to admissibility of photocopy of a document, by virtue of sections 88, 89, and 90 of the Evidence Act, a photocopy of a document is inadmissible in evidence if the whereabouts of the original document is not explained. See the case of Alade versus Olukade, voted in 1976 to SC 183. Exhibit D3 is a photocopy of the letter sorry. See Alade versus Olukade, voted in 1976 to SC 183. Exhibit D3 is a photocopy of the letter of termination, and for it to be admissible, it must have satisfied certain conditions as spelled out. In other words, for a photocopy like Exhibit D3 to be admissible in court, the law requires the party relying on it to prove it by producing the original copy, or at least lay foundation for producing a photocopy. Exhibit D3 is not an original, and no foundation was laid by the defense counsel before tendering it. Excuse me. Without proper foundation, being laid, a photocopy of a document is not admissible because that photocopy is not primary evidence, but secondary evidence. PLC more reported in 1996 for Nigeria Weekly Law Report, part 443, page 470, Court of Appeal. In the case of Habib Nigeria Bank Limited versus Koya, reported in 1992, 7 Nigeria Weekly Law Report. Sorry. In Habib Nigeria Limited, Koya, reported in 1992, 7 Nigeria Weekly Law Reports, part 251, page 43 at 56, Pemukta JCA, as he then was, held that, and I quote, if the original is not tendered but a photocopy, proper is to, as to the whereabouts of the original must be laid. That is not enough to simply say that the witness seeking to tender the photocopies had collected the said copies from marker, as it cannot be presumed that by so saying the originals are in marker, or that the person with whom the originals had refused to give them to the witness. When such foundation is laid, the photocopy becomes admissible without any stress, unquote. See also the case of Amico Construction Company Limited versus Ag International Limited, reported in 2015, 17 Nigeria Weekly Law Report, part 14S7, page 146 at pages 180 to 181. It's a Court of Appeal case. Coming to the present case, no foundation was laid by the defense counsel as to the whereabouts of the letter of termination. It is therefore in the firm view of this court that said inadmissible and ought not to have been admitted. Consequently, it is hereby marked rejected, and I so find and hold. Furthermore, from the evidence coming, the claimant maintained that he never received the so-called termination letter. That is Exhibit 3 from the defendant. Rather, his status remained suspended staff of the defendant. Be it as it may, whether there is issue of a document that the other part denies its existence on the ground that he was never in receipt of the same, it lies on the party who relies on the document to lead evidence that the other party received the documents. In the case of Agbaje versus Fashola, reported in 2008, 6 Nigeria Weekly Law Report, part 1082, pages 90 at 42. A to D. The court held that proof of delivery of such documents can be established in 3 ways. That first, 1, dispatch book indicating receipts, or 2, evidence of dispatch by registered post, and 3, evidence of witness credible enough that the person was served with the document. In the case hearing, the defendant could not leave any evidence in proof of the fact that the claimant received the termination letter or had acknowledged, had not knowledge of the same. In this vein, the so-called termination letter or termination of the appointment of the claimant only exists in the realm of the defendant and not in that of the claimant, and I so hold. The claimant's relief, 1, is for a declaration that the claimant's suspension is unlawful. What appears from the evidence before me is that the claimant was employed by letter dated 12 December 2010 until 10th July 2019, when he was issued the letter of suspension dated 10th July 2019, based on the union activities. The said suspension letter is reproduced below. That is letter of suspension, sabotage of GMT business at the ports. With respect to the above captioned, you are hereby placed on suspension for abandoning your workplace to assist in the illegal disruption of GMT business at the ports on the 9th day of July 2019. Please note that this suspension is in effect until the extent of your involvement is investigated and established. Depending on the outcome at the end of the investigation, you can either be recalled or an alternative action be taken. the suspension is effective immediately. That was the end. In the case of Professor C.C. Weke versus Nnamdi Azikiwe University, Awka, reported in 2017, 18 Nigeria Weekly Law Reports, suspension was said to mean a temporary privation or deprivation, cessation of stoppage, or stoppage of or from the privileges and rights of the person. It carries or conveys a temporary or transient disciplinary procedure which keeps away the victim or the person disciplined from his regular occupation, calling either for a fixed or terminal period or indefinitely. The disciplinary procedure gives the initiator of the discipline a period to make up his mind as to what should be done to the person facing the discipline. In other words, suspension is usually a prelude to dismissal from an employment. It is neither a termination of the contract of an employee nor a dismissal of the employee. It merely operates to suspend the contract rather than terminate the contractual obligation of the parties to each other. See the University of Calabar versus Isiaga, started in 1997, 502, page 719. See also Longe versus FBN PLC, reported in 2010, 6 Nigeria Weekly Law Report, part 119, referred to at is page 476, paragraph B to E. From the words of the letter of suspension, it is clear that the claimant is placed on suspension, but there is to be an investigation, the outcome of which will determine the next step. The said letter, dated 10 July 2019, was issued to the claimant on the 15th day of July 2019. Unfortunately, the court is not guided by the presence of any staff handbook or disciplinary procedure of the defendant's company, but common sense detects some time would lapse in the course of the investigation and the outcome of which will lead to the next step in the of the claimant, either for good or for bad. Under cross-examination, the defendant's witness claimed an investigation was conducted and the technical manager of the defendant's president, but could not remember for how long or whether there was an official report of the investigation. In addition, the claimant was not invited and no reports or evidence of the investigation was tendered in court. It is clear from the above that the defendant failed to conduct a proper and fair investigation. No doubt, an employer has inherent powers to discipline an employee. However, any disciplinary action against an employee must be consistent with the employee's contract of employment, or in the absence of any express provisions, as in the present case, there must be some acknowledgement of the human dignity of the employee in the discipline by the employer. In this case, while the defendant has the case of while the defendant has inherent powers to discipline the claimant, as can be gleaned from the cases of Udema versus Nigeria Coal Corporation, started in 1991, 3 Nigeria Weekly Law Report, part 180, page 479 at 486. and also Meafen versus University of Jos Consultancy Limited, reported in 2013, 21904, Court of Appeal, pages 33 to 34. It is the law that an employee should not be kept under suspension indefinitely without initiating and concluding disciplinary proceedings against him, as this puts him under the undue hardship and makes it impossible for him to go seek alternative employment. See the case of Faturoti versus University of Lagos, quoted in 2016, 65 NLLR, part 233, page H21. It is equally the law that the employee on suspension remains an employee and in the service of his employer. See Olowu versus Ecobank Nigeria Limited, reported in 2016, citation fully supplied. Furthermore, by virtue of Section 40, the 1999 Constitution, every person shall be entitled to assemble freely and associate with each person, and in particular, he may form or belong to any political party, trade union, or any association for the protection of his interests. Now, Section 44, Sub 1, A to D of the Trade Union Act provides that, and I quote, an act done by a person in contemplation of further trade disputes shall not be actionable in thought or any or more of the following grounds, only that is to say, A, that it induces other persons to break a contract of employment, or B, that it is an interference with the trade business or employment of some other persons, or with other persons to dispose of his capital or his labor. C, that it consists of his threatening that a contract of employment, whether one to which he is a party or not, will be broken, or D, that it consists in his threatening that he will induce some other persons to break a contract of employment to which that other person is a party. Now, it is important to note that the present case, that is the defendant's witness under cross-examination, said, referring to the claimant, quote, he disrupted the actions of the company by blocking the way to cars and staff. It was as a result of maritime union problems to which the claimant is one, unquote. Also, paragraph 10 of the defense witness statement on oath reads as follows. In response to paragraph 29 and 30 of the statement of the defendant assessed that the said suit sought injunctive reliefs against Maritime Workers Union of Nigeria. My name is John to disrupt the business of the defendants, which it did through the claimant and others, until the claimant was disowned by the union. Hence the need for the defendant to approach the court for protection, and the court agreed and made an order of interim injunction against the Maritime Workers Union of Nigeria, who incidentally is also not a party in this suit, apart from the fact that all the issues are no longer life issues, as all the issues have been resolved conclusively. The interim order against Maritime Workers Union of Nigeria is pleaded and shall be found upon during the trial. And that was the defense counsel. Wow. The above are pointers to the fact that the claimant's suspension arose as a result of his involvement in union activities, in addition to the fact that the defendant issued letters of suspension to the claimant whilst a subsisting court order to maintain status was pending. These courts held in plethora of cases that the termination on grounds of trade union activity is an unfair labor practice. This is because it does not only infringe ILO injunctions as a freedom of association, but also infringes on the constitutionality guaranteed freedom of association provided under Section 440 of the 1999 Constitution. In the light of the foregoing, I hold that the claimant's suspension, which stemmed from the claimant's involvement in union activities and which suspension seems to last time without end, is unlawful. The claimant's relief number 2 is order of this court directing a defendant to pay all the salaries of the claimant from the date of suspension to the conclusion of his suit at the rate of 83,119 naira 9 kobo per month. This flows from relief 1 above. Now, that there was a suspension. Somebody is any evidence that the employment claimant was properly brought in. From the time of the suspension till the time of instituting this case, there is nothing to show that the claimant worked with the defendant or that he was recalled to his duty post. This kind of scenario is one which is akin to constructive termination of employment. The court cannot make an order for the claimant to be paid the sum of 83,119 naira 9 kobo every month for the period he did not work. However, it can award damages for constructive termination of employment. In this light, the court assesses the sum of 5 million naira as damages for the constructive termination of the employment of the claimant, and I so hold. Relief number 3 is from directing the defendant to pay to the claimant all his entitlements and welfare packages in line with the collective bargaining agreement starting from 2018. This relief also flows from relief 1, which has been granted. However, the court has seen exhibits D4 and D8. That is the judgment in suit number NICN/LS/601/2017, which was decided based on the terms of settlement filed by the parties, dated 19th April 2018, and memorandum of agreement between the defendant and the union, agreeing on the collective bargaining agreement for the year 2018, dated 5th December 2019, respectively. Whilst paragraph 9 of settlement says that, and I quote, agreed to fix a date, etc., on conditions of service of their employment for the year 2018. The heading of Exhibit DF says, quote, memorandum of agreement between, etc., on collective agreement Agreement CBA for the year 2018 with the words effective 1st January 2019, handwritten as if it is an afterthought in the duration clause initiated by a party. In the circumstance, the court is minded to grant this relief only to the extent that it shall be from 2018 to July 2019, which signals the beginning of the constructive termination of the claimant veiled as suspension. The defendant is hereby ordered to pay to the claimant all his entitlements and welfare packages in line with the collective bargaining agreement starting from 2018 to July 2018, when the claimant was suspended, thereby leading to the constructive termination of his employment with the defendant. The claimant's relief 4 is for interest on the total judgment sum at the rate of 21%. There is no evidence that employment contract agreements made provision for the charging of interest in the course of default. It is the law that a court can only award a pre-judgment interest where there is an agreement for payment of interest or under mercantile custom or under a principle of equity, such as breach of fiduciary duty. In such cases, prejudgment interest must be specifically included and strictly proved. See the case of United Bank of Africa PLC versus Mrs. Doreen Nkoleka, reported in 2013. And Olasu Greg Agbabiaka versus Bank of Nigeria PLC, reported in 2006. And then the case of Belliet. Sorry, these cases I mentioned are their citations are fully supplied. Then in the case of Belliet Nigeria Limited versus Alhaji Mustafa Kachala, reported in 1995. Citation supplied. Ogun JSA held, and I quote, there clearly is a difference between award of interest, such and proof, and the award of interest on a judgment debt, which is purely statutory and can only be awarded if there are provisions to that effect in the law or rules of courts. In view of the above, I find that the claimant has adduced unsatisfactory evidence to show his entitlement to the claims for ante or prejudgment interest. I therefore find and hold that the claim for interest fails, and same is hereby dismissed. The claimant's fifth claim is for the sum of 550,000 naira, being the solicitor's fee for the prosecution of claimant's action. It is the law that cause follows events, and though debatable, it is usually awarded to a successful party in litigation who has proved his entitlements to same in the class of special damages. See the cases of 1G versus Coastal Services Nigeria Limited, reported in 2004. LPELR 2106, it's a Supreme Court case. Also, in Yakubu versus Ministry of Housing and Environment, Bauchi State, reported in 2021, 12th Nigeria Weekly Law Report, part 1791, page 465. It was held inter alia, and I quote, cost of an action and cost of filing the action are one and the same thing. The general rule is that cost follows event, and a successful party is entitled to cost. The award or refusal of cost is at the discretion of the court, provided it is exercised judicially and judiciously. Costs are awarded to indemnify the successful party, not as punishment on the party who pays them, nor is cost given as a bonus to the party who receives them. In this case, as well as given the circumstances of the case, this cost is not minded to award any cost as solicitor's fee. Rather, each party should bear their respective costs. On the whole, the claimant's case succeeds as follows. Relief number 1 succeeds. Relief number 2 succeeds only to the extent that the termination of the employment of the claimant was done constructively. Hence, he is entitled to the sum of 5 million naira as damages from the defendant for constructive termination of employment. Relief number 3 succeeds only to the extent that the defendant shall pay the claimant his entitlement and welfare package in line with the collective bargaining agreement CBA from 2018 to July 2019, when he was suspended. A suspension which led to constructive termination of the employment of the claimant. Relief 4 fails, and Relief 5 also fails. The court makes no orders to costs. Parties are to bear their respective costs, and this judgment is entered accordingly.
As the court pleases. As the court pleases. Thank you very much, my lord.
Thank you.
My lord, I'm most grateful for the well-considered judgment, sir.
Thank you very much.
My lord, I'm so sorry. I lost touch at some point due to the network lag. I'm not quite sure if this is the sister's case or this is Aka's case, my lord.
The sister
so I can to enable me properly announce the appearance for both cases. Sorry, my lord.
Okay, but unfortunately, I'm not going to read out everything that is here now. You can see the volume.
Yes, my lord. My lord.
Yes, my lord.
My lord, the case is verbatim. The 2 cases are verbatim. So I don't know if the judgment is accordingly too, but we understand if the court cannot read this.
There are sister cases. So let me. What do I do? Do I read out the end?
Yes, my lord. The end, the judgment.
The judgment.
The judgment, my lord.
My lord, that's okay. We can. Yes, my lord can speak. Yes, we are okay with that, sir.
Okay, let me see.
As soon as the money are ready, because so you can just give it at certain day.
Yes, I will call it up so that I can take your appearances. But eventually,
as a couple,
since they're almost the same thing, I will deem it as having been read too. Because when you get the CTC of one, it is the same thing I wrote that I in the other one. So please call number 2, please. Yes.
Number NICM/LA/98/2021 between Jeremiah Ofoafo and GMT Nigeria Limited.
Are they present?
Parties absent.
Appearances.
With respect, my lord.
Yes.
My lord, my name is Anthony Atata. I'm appearing for the claimant, my lord. Atata, ATA, as in town.
Yes. Yes.
My lord, with deference, Adeyemi, I only hold the brief of Femi Adisa Isikalu for the defendants, my lord.
Come, give me the case file. Okay. Very well. So, like in this case, even we are there's a sister case, and in fact everything is almost the same. So do I read out the, where do I start to read out?
The judgment, my lord.
The judgment, okay.
Yeah, dealing with the release.
Okay. Okay. So I will, this is where actually the rulings start from. The claimant's relief 1 is for a declaration that the claimant's suspension is unlawful. What appears from the evidence before me is that the claimant was employed by a letter dated 17th March 2008 until 18th July 2019, when he was issued letter of suspension dated 10th July 2019 based on union activities. The said suspension letter is reproduced below. Do I have to reproduce it?
No, my lord.
With respect to the above captioned, you are hereby placed on suspension until the extent of your involvement in the illegal disruption of GMT business at the port on the 8th July 2019 is investigated and established. Depending on the outcome at the end of the investigation, you can either be recalled or an alternative action be taken. The suspension is effective immediately. So the court went on to say, in the case of Professor Sisiweke versus Nnamdi Azikiwe University, Oka, reported in 2017, 18 Nigeria Weekly Law Reports, suspension was said to mean temporary privation or deprivation, cessation or stoppage of or from the privileges and rights of a person. It carries or conveys a temporary or transient disciplinary procedure, which keeps away the victim or the person disciplined from his regular occupation or calling either for a fixed or terminal period of indefinitely, period or indefinite. The disciplinary procedure gives the initiator of the discipline a period to make up his mind as to what should be done to facing the discipline. In other words, suspension is usually a prelude to dismissal from an employee. It is neither a termination of the contract of an employee nor a dismissal of the employee. It merely operates to suspend the contract rather than terminate the contractual obligation of the parties to each other. University of Calabar versus Esiaga, quoted in 1997, page 5 Nigeria Weekly Law Report, part 502, page 719. And also the case of Longe versus FBN PLC, quoted in 2010, 6 Nigeria Weekly Law Reports, part 1189. page 476, paragraph B to E. Now, from the words of the letter of the suspension, it is clear that the claimant is placed on suspension, but there is to be an investigation, an outcome of which will determine the next step. The said letter dated 10 July 2019 was issued to the claimant on the 15th day of July 2019. Unfortunately, the court is not guided by the presence of any staff handbook or disciplinary procedure of the defendant's company, but common sense dictates that some time would lapse in the course of the investigation, in the course for investigating the outcome, which will lead to the next step in the discipline of the claimant, either for good or for bad. Under cross-examination, the defendant's witness claimed an investigation was conducted with the CSO and the technical manager of the defendant being present, but he could not remember for how long or whether there was an official report of the investigation. In addition, the claimant was invited and no report or evidence of the investigation was tendered in court. It is clear from the above that the defendant failed to conduct a proper and fair investigation. No doubt, an employer has inherent powers to discipline an employee. However, any disciplinary action against an employee must be consistent with the employee's contract of employment, or in the absence of that, any express provision in the present case, there must be some acknowledgement of the human dignity of the employee in the discipline by the employer. In this case, while the defendant has inherent powers to discipline the claimant, as can be gleaned from the cases of Udema versus Nigeria Coal Corporation reported in 1991, and also Miafen University versus University of Jos Consultancy Limited, reported in 2013. Citation fully supplied. It is the law that an employee should not be kept under suspension indefinitely without initiating and concluding disciplinary proceedings against him, as this puts him under undue hardship and makes it impossible for him to go seek alternative employment. See the case of Faturoti versus University of Nigeria, reported in 2016, 6 NLR, part 233, page 821. It is the law that an employee on suspension remains an employee and in the service of his employer. See Olowu Limited, reported in 2016, 68 Nigeria Labor Law Report, part 242, page 90 at 121. Furthermore, by virtue of Section 40 of the 1999 Constitution, every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interests. Now, Section 44, subsection 1A to D of the Trade Union Act provides that an act done by a person in contemplation of furtherance of trade disputes shall not be actionable in tort on any one or more of the following grounds only. That is to say, 1, that it induces some other persons to break a contract of employment. 2, that it is an interference with the trade, business, or employment of some other person, or with the right of some other person to dispose of his capital or his labor. C, that it consists in his threatening that the contract of employment, whether one to which is a party or not, will be broken. Or D, that it consists in the threatening that he will induce some other persons to break a contract of employment to which that other person is party. Unquote. Now, it is important to note that in the present case, the defendant's witness under cross-examination said he, referring to the claimant, disrupted the actions of the company by blocking the way to cars and staff. It was as a result of maritime union problems to which the claimant is one, unquote. Also, paragraph 10 of the defense witness statement on oath reads as follows, and I quote, in response to paragraph 29 and 30 of the statement of facts, the defendant assessed that the said suit sought injunctive reliefs against Maritime Workers Union of Nigeria, who is in the habit of coming to disrupt the business of the defendant, which it did through the claimant and others, until the claimant was disowned by the union. Hence, the need for the defendant to approach the court for protection, and the court agreed and made an order of interim injunction against the Maritime Workers Union of Nigeria, who incidentally is also not a party to this suit, apart from the fact that the issues are no longer life issues, as all the issues have been resolved conclusively. The interim order against the Maritime Workers Union of Nigeria is pleaded and shall be found upon during the trial, unquote. The above are pointers to the fact that the claimant's suspension arose as a result of his involvement in union activities, in addition to the fact that the defendant issued letters of suspension to the claimant whilst a successful court order to maintain status quo was pending. This court has held in plethora of cases that determination on grounds of trade union activities is an unfair labor practice. This is because it does not only infringe ILO injunctions as to freedom of association, but also infringes on the constitutionality guaranteed freedom of association provided under Section 40 of the 1999 Constitution as amended. In the light of the foregoing, I hold that the claimant's suspension, which stems from the claimant's involvement in union activities, and which suspension seems to last time without end, is unlawful. The claimant's relief number 2 is for an order of this court directing the defendant to pay all the salaries of the claimant from the date of suspension to the conclusion of this suit at the rate of 92,000 naira a month. This relief flows from relief 1 above. Now, there is evidence before me that there was a suspension of the claimant, a suspension which lasted without any evidence that the employment of the claimant was properly brought to an end. From the time of the suspension to the time of instituting this case, there is nothing to show that the claimant worked with the defendant or that he was recalled to his duty post. This kind of scenario is one that is akin to constructive termination of employment. This court cannot make an order for the claimant to be paid the sum of 92,000 naira every month for the period he did not work. However, it can award damages for constructive termination of employment. In this light, the court assesses the sum at 10 naira. The sum of 5 million naira as damages for the constructive termination of the employment of the claimant, and I so hold. Relief number 3 is for an order of this court directing the defendant to pay to the claimant all his entitlements and welfare package in line with the collective bargain agreement starting from 2018. This relief also flows from Relief 1, which has been granted. However, the court has seen Exhibits D4 and D8, the judgment in suit number NICN/LS/601/2017, which was decided based on the terms of settlement filed by the parties, dated 19th April 2018, and memorandum of agreement between the defendant and the union agreeing on the collective bargaining agreement for the year 2018, dated 5th December 2019, respectively. Whilst paragraph 9 of the terms of settlement says, and I quote, that both parties have agreed to fix a date, etc., on condition of service of the applicant's employees for the year 2018, comma, the heading of Exhibit D8 says, quote, memorandum of agreement between, etc., on collective bargain agreement, CBA, for the year 2018, with the words effective 1st January 2019. Handwritten as if it is an afterthought in the duration clause initiated by a party. In the circumstances, the court is minded to grant this relief only to the extent that it shall be from 2018 to July 2019, which signals the beginning of the constructive termination of the claimant, veiled as suspension. The defendant is hereby ordered to pay to the claimant all his entitlements and welfare package in line with the collective bargain agreement starting from 2018 to July 2019, when the claimant was suspended, therefore thereby leading to the constructive termination of his employment with the defendant. The defendant's relief number 4 is for on the total judgment sum at the rate of 21%. There is no evidence that the employment contract agreement made provision for the charging of interest in case of default. It is the law that a court can only award a pre-judgment interest where there is an agreement for payment of interest or under mercantile customs or under a principle of equity, such as breach of fiduciary duty. In such cases, the prejudgment interest must be specifically pleaded and strictly proved. See the cases of United Bank of Africa PLC versus Mrs. Doreen Nkoleka Oranuba, reported in 2013, and also Olusakomi Greg Ababiaka versus First Bank Nigeria Limited, PLC, reported in 2006, LPELR 11756. It is a 21. It's a Court of Appeal case. In the case of Belit Nigeria Limited versus Alhaji Mustafa Kachala, reported in 1995, citation supplied, that agency held, and I quote him, there clearly is a difference between award of interest prejudgment, where plaintiff must specifically claim such and prove it, and also the award of interest on a judgment debt, which is purely statutory and can only be awarded if there are provisions to that effect in the law or rules of court. So in view of the above, I find that the claimant has adduced unsatisfactory evidence to show his entitlement to the claim for, to the claim for anti-prejudgment interest. I therefore find and hold that the claim for pre-interest fails and same is hereby dismissed. The claimant's fifth claim is for the sum of 550,000 naira, being the solicitor's fees for the prosecution of claimant's action. It is the law that costs follow events, and though debatable, it is usually awarded to a successful party in litigation who has proved his entitlement to same in the class of special damages. See the case of 1G versus Coastal Services, Nigeria Limited. Citation supplied was reported in 2004. Then in the case of Yakubu versus Ministry of Housing and Environment, Bauchi State, reported in 2021, 12 Nigeria Women Report, part 1791, page 465. It was held inter alia, and I quote, cost of an action and cost of filing the action are one and the same thing. The general rule is that costs follow events, and a successful party is entitled to costs. The award or refusal of costs is at the discretion of the court, provided that it is exercised judicially and judiciously. Unquote. Costs are awarded to indemnify the successful party, not as punishment on the party who pays them, nor is cost given as a bonus to the party who receives them. In this case, as well as given the circumstances of the case, this court is not minded to award any costs or solicitor's fees. Rather, each party should bear their respective costs. On the whole, the claimant's case is as follows. Relief number 1 succeeds. Relief number 2 succeeds only to the extent that the termination of the employment of the claimant was done constructively. Hence, he is entitled to the sum of 5 million naira as damages from the defendant for constructive termination of employment. Number 3 succeeds only to the extent that the defendant shall pay the claimant packages in line with the collective bargaining agreements, but from 2018 to 2019, when he was suspended, a suspension which led to the constructive termination of the employment of the claimant. Relief number 4 fails, and relief number 5 equally fails. The court shall make no orders to costs, and the parties shall bear their respective costs. And that is the judgment of the court, and it is entered accordingly.
As the court, please.
As the court pleases.
Very well. Yes.
Yes. Yeah. Thank you very much, my lord, for the ruling, for the judgment.
Thank you.
We appreciate the diligence.
Okay, thank you very much.
My lord, we are equally thankful for the industry and the resourcefulness in delivering these judgments. And I wish the court a lovely vacation, sir.
Thank you, and I wish you the same. And long life and prosperity. That is
As the
how
court pleases.
Amen.
everybody will be shining next year.
As the court pleases.
Okay. Which one is this? Is it the next one? Okay. Are there? Yes. Okay.
Case number NISS/164/2021 between Mr. Kingsley UK and Fidelity Bank.
Artist absent. Appearances, please.
May it please, my lord?
Yes.
My name is DC Kem Derem. My lord, I appear for DC, Washington, DC, initials. Kem Derem is spelled, my lord. K-E-M.
Okay, I can spell it.
As please. My lord, I appear for the claimant.
Very well.
With the greatest respect to this honorable court,
Yes.
my lord, my name is George Lekwa. My humble appearance is for the defendant, sir.
Very well.
Yes, sir.
Thank you.
Yeah, arguments with the financial basis.
Eh?
I skip the arguments with the financial basis.
You skip the.
Yeah, financial basis.
Okay, okay. Okay. Mr. Lekwan, Mr. Kemdirim, please, in this particular judgment, I'm going to do this. I will skip the submissions in your addresses, please, because it will take a whole lot of time. Since you are going to get the CTC of it, once you get it, you know what you wrote. You will get it.
Very well, sir.
So,
Very well, sir.
I skip the middle and go to the end. Okay.
Very well, my lord.
All right. So this suit was instituted by the claimant via the general form of complaint dated and filed on the 17th day of June, 2021, asking for the following reliefs. A declaration that the claimant is not indebted in any form or manner to the defendant, having regard to the agreement that his indebtedness, if any, shall be written off upon disengagement, and indeed has been written off. B, a declaration that having regard to the annual gross salary of the claimant and the 50% thereof, being his final entitlement as approved by the defendant, that the claimant was short paid by 4,206,859 naira 16 kobo. C, the declaration that the continued detention of the title document of claimant's house at Lekki Gardens, Phase 2, House 104, Unit 3, along Lekki Ekpe Expressway, Lekki, is illegal, having regard to the fact that claimant is not indebted to the defendant, as indebtedness has been written off. 4, an order directing the defendant to pay the sum of 4,206,857 naira 16 kobo to the claimant, being his final entitlement, which was short paid and has remained unpaid till date. 25% interest on the judgment sum per month from 17 February, when it became due, until judgment is delivered, and 25% interest on the judgment sum per month from the date of judgment until the judgment sum is paid. 5, an order directing the defendant to release forthwith to the claimant his house, title document situated and lying at Lekki Gardens, Phase 2, House 104, has S104 Unit 3 along Lekki Epe Expressway, Lekki, Lagos, within 7 days from the date the order is made. Then 6, an order of perpetual injunction restraining the defendant, her agents, assigned on howsoever called from harassing, threatening, or demanding any form of payment from the claimant as indebtedness. And finally, the cost of this action. So the gist of the claimant's statement of fact is that he was an employee of the defendant and he rose to the position of manager of the branch of the defendant before he resigned his appointment in February 2020. That prior to his resignation, he took ill and he applied for medical leave. Given the circumstances of his illness, he applied for a credit card loan from the defendant to continue his treatment overseas. Subsequently, in early January 2020, the defendant nominated a couple of medical outfits for an independent assessment of the claimant's health, which led to an invitation of a meeting of 6 February 2020. In the said meeting, the claimant made requests that no deductions be made on his terminal benefits, which is 50% of his annual gross, and the cancellation of all his outstanding debts due to loss of income and his current health. The defendant urged him to put this in writing. The claimant was assured by the CHRO, Mr. Charles Wachku, that he would communicate claimant's request to management for approval. Thereafter, claimant tendered his resignation letter on 17 February 2020. After resigning, on the calculation of his terminal benefits, the defendant issued him an end of service statement account dated 6 February 2020, showing that the claimant was indebted to the defendant to the tune of 13,132,556 naira 48 kobo. Contrary to the agreement that the claimant's debt would not be debited from his terminal benefits, except the credit card debt. The claimant protested this, leading to a reversion of 13th March 2020, when another EOS, that is end of service statements, was issued, leading to the account of the claimant being credited with 10 million on the 12th day of March 2020, a day prior to 13th March 2020. That this amount was a short pay because as at the time he retired, his annual gross pay was 23,392,809 naira, to which 50% should be 11,696,404 naira 50 kobo, and not 10,058,660 naira 12 kobo that was approved for payment. Inside this sum, there were deductions of 350,000 naira and 222 naira, 912,033 kobo respectively. Illegal deductions of 1.4 million naira as tax. Also, the defendant claimed that the claimant resigned on 6 February 2020, whereas it was on 17 February 2020 that he resigned. Therefore, the defendant miscalculated the claimant's salary to end on pro rata basis on 6 February 2020, thereby paying him 11 days salary. in sum of 765,381 naira. Given that his monthly salary was 1,949,400 400 naira 75 kobo. All of the above short payments and deductions led to the nature of the relief sought by the claimant. So in the defendant's statement of defense, dated 16th November 2021, but filed on the 17th, the defendant denied each and every allegation of facts in the claimant's statement of facts. The defendant stated that on the ill health of the claimant, the independent assessors were engaged to assess the health status of the claimant in view of the medical reports submitted by the claimant and that of the independent medical assessors. It was clear that the claimant lacked the capability to continue working with the bank. An opinion the claimant agreed with in the meeting, thereby leading to the advice to resign. That initially, the claimant was penciled down to be exited from the defendant based on his poor appraisal of 2019. However, based on his ill health, same was commuted to redundancy. That the defendant offered to pay claimant 50% of his annual gross salary without consent from his indebtedness to the bank, which debt was in the sum of 34,987 naira, 34,987,182,057 naira. That once it was true that the claimant made a request on the 6th February 2020 via email for a waiver of outstanding and no deduction should be made on his terminal benefits, the defendant refused his request on the ground that the funds are depositor's money, and such waiver is contrary to public policy and extant regulation of the Central Bank of Nigeria, CBN. However, the defendant approved a memorandum of 6 months for the claimant, which was communicated to him and led to the payment of 10,058,615 naira 12 kobo to the claimant. This sum was paid to the claimant without netting off the 34,987 naira 182 34,987,182 million 12 kobo owed by the defendant by the claimant, that the claimant has no policy on terminal benefits as such. What was paid to the claimant was his 6 months net salary on his redundancy severance pay. And as such, he did not short pay the claimant in any way, as the money was not calculated as gross, but as net. The title documents of the claimant in the hands of the defendant were deposited as collateral for the loans collected by the claimant. That the claimant's resignation took effect on 6 February 2020 when the defendant approved the resignation, and not 17 February as averred by the claimant. So, arising from the assertion of the defendant that the claimant is indebted to her to the tune of 34 million odd, The defendant also counterclaimed against the claimant as follows. A declaration that the defendant is entitled to the claimant's house documents used as collateral for the loan advanced to the claimant until the claimant liquidates his indebtedness to the tune of 34,987 naira, 1,182 naira 12 kobo. B, an order of specific performance compelling the claimant defendant to counterclaim to pay its indebtedness to the tune of 34,987,182 naira 12 kobo. C, an order empowering the defendant counterclaimant to sell the claimant defendant to the counterclaim's house at Lakey Gardens Phase 2, House S104, Unit 1 along Lekki Ekpe Expressway, Lagos, to recover the defendant's indebtedness of the sum of 34 million odd. Then D, interest on the said sum of 34,987,182 naira 12 kobo at the rate of 15% till judgment is given and 20% till full liquidation. And lastly, the cost of it must be noted that on receipt of the statement of defense of the defendant and counterclaim, the claimant filed a reply to the defense to the counterclaim dated 1st February 2022, but filed on 15th February 2022. Trial in this matter commenced before the court on the 22nd of February 2022, to which the claimant was called as a witness to testify in chief. During his examination in chief, he tendered documents that were admitted in evidence and thus exhibits. Subsequently, he was cross-examined by the defendant. Claimant also called one Mr. Charles Wanchuku and Fina Eze, who were subpoenaed at the instance of the claimant to come and testify. They were also cross-examined. There was no re-examination, and thereafter, the claimant closed his case on the 12th day of October 2022. On the part of the defendant, she opened her defense on the 2nd day of May 2023 by calling one Franklin Adagugu, who identified himself as the lead workshop ethics practice of the defendant. He adopted his witness statement on oath, gave oral evidence. He did not tender documents. He was cross-examined by the counsel to the claimant. There was no re-examination, and thereafter the defendant closed his case, his defense on the 28th day of February 2024. The case was then adjourned to enable parties file, exchange, and adopt their final written addresses. So this is the place I said I will jump, gentlemen, and I'm going to do right. I'm going to do that. And this is what I'm jumping is the defendant's final written address. It is here. It's here, it's from me. Then the claimant's final written address. That must have been after receipt of the defendant's final written address. And then at the end of it, the court, after looking at both submissions, that is, after having gone through the case of the claimant, the defendant's defense and counterclaim, the evidence before the court, and the final written addresses of the parties, the court distilled two issues for determination. And these are: one, whether, given the circumstances, the claimant has proved this case to be entitled to the relief sought. Two, whether the defendant counterclaimant has proved her case to be entitled to the relief sought also. Bearing in mind that the defendant formulated 5 issues and the claimant formulated 8 issues in each of their final written addresses, the court will address such issues when necessary in the body of the judgment. Generally, in a civil matter, cases are won on preponderance of evidence. A party who asserts or alleges bears the burden of proving his case with evidence to support his assertion in the body of his pleadings. See the case of Alhaji Tajuddin Ibrahim Olagunju versus Alhaja Habibat Yahaya, reported in 2004, 11 Nigeria Weekly Law Report, part 883, page 24. Failure to lead evidence in support of his case is fatal to his case. In the case hearing, the case of the claimant is that he was short-paid in his terminal benefits by the defendant. Not only that, he claims that his indebtedness to the defendant, which runs into millions of naira, was written off by the defendant. That this was part of the conditions leading to his resignation from the employment of the defendant. On the matter of being short-paid, his position is that what was agreed was payment of 50% of his annual gross salary, which from his calculation was 11,696,404 naira 50 kobo, given that his 100% annual gross salary is 23,392,809 naira. That, however, what the defendant approved for him to be paid was 10,058,650 naira 12 kobo, representing a shortfall of 1,637 naira 754 kobo, 637,754 naira 38 kobo. Not only that, after deducting an alleged illegal sum of 1,400,000 naira as tax on emolument, at the sum of 1.9 million naira as deduction for credit card debt, that the sum of 572,912 naira 33 kobo, thereby totaling the sum of 3,873,839 naira 86 kobo as deductions. The defendant paid him the sum of 6,184,810 naira as balance for his terminal benefits. The contention of the claimant is that what he was entitled to be paid as 50% gross was 11,696,404 naira 50 kobo. And the only deductions that were to be made from that sum was 169,700 640 naira 45 kobo, representing 10% tax deduction as against 1,400,000 that the defendants deducted. The sum of 1,900,927 naira 53 kobo as credit card debts, totaling the sum of 2,070,567 naira 98 kobo. Therefore, if the sum of 70,567 naira 98 kobo was deducted from the 50% of his annual gross, which is 11.6 odd. What the defendant should pay him is 9,625,836 naira 52 kobo, as against the sum of 6,184,810 naira that the defendant paid. Also, the claimant's resignation took effect from 17th February 2022, as against the 6th of February 2020, as against the 6th of February 2020, stated by the defendant. By the calculation of the claimant, he was also short-paid by 11 days of work with the defendant, which is the differential between 6 February and 17 February. This short payment is the sum of 765,831 naira. If this sum I mentioned now is added to the 9.6 odd million that they owe him, that the defendant ought to have paid him his benefits, his terminal benefits, which should have been 10,391,666 naira 52 kobo. When the sum of 6,184,819 naira, which the defendant eventually paid him, is deducted from the terminal benefits of 10,391,666 naira 52 kobo due to the claimant, then the balance the defendant now owes him is 4,206,859 naira 52 kobo. The above forms the basis and the gamut of the suit of the claimant against the defendant. Well, be that as it may, the tract law is that pleadings must be supported by evidence. Any pleadings not supported by evidence is deemed abandoned. In this light, the court will look at the pleadings of the claimant in relationship to the evidence led in support of the same. As to how he arrived at the calculation of the 11,696,404 naira 50 kobo as 50% of his annual gross salary, the claimant tendered Exhibit C3, which captured his reviewed gross pay to be 23,392,809 naira. I'm sorry, 23,392,809 naira. Yes. It is the 50% of this sum that he calculated to be 11,606,404 naira 50 kobo. This court has taken a keen look at the pleadings and evidence before her, and she's satisfied that the claimant has been able to prove how he arrived at the sum of 11.6 million odd, representing 50% of his annual gross salary. As regards being entitled to 50% of his annual gross salary as terminal benefits, the position of the claimant is that this was part of the agreement reached on the 6th day of February 2020, when the management of the defendant advised him to resign on health grounds. Responding to this, paragraph 12 of the defendant's statement of defense, the defendant stated, and I quote it, defendant further states that the bank benevolently offered to pay the claimant 50% of his annual gross pay as annual benefit without deducting same from his indebtedness to enable him continue with his medication and without prejudice to his indebtedness of the 34,987 naira 987,182 naira 57 kobo. Unquote. The general principle of law is that facts admitted need no further proof. See Dr. Aga Eresiaike and two others, versus Elsa Jackson Orikoha and two others, quoted in 10. 8 Nigeria Weekly Law Report, part 1196, page 421 at 430, where the court held, and I quote, facts not denied nor challenged, or which admitted or deemed admitted need no further proof, unquote. In this, the defendant, having admitted in paragraph 12 of her statement of defense that the bank benevolently offered to pay the claimant 50% of his annual gross salary as benefit, corroborate with the argument of the claimant that the defendant actually agreed to pay him the said 50% of his annual gross salary, annual gross as terminal benefit. Other money claimed by the claimant is the sum of 765,831 naira, which tagged money for 11 days of work from 6 February 2020 to 17 February 2020, when he resigned his appointment. Before delving into this, the issue of this sum, I want to say that the issue of the effective date of registration of the claimant seems to generate argument between the claimant and the defendant. So the defendant, the effective date of resignation of the claimant is 6 February 2020, when he was asked to resign, which is the same as when his resignation was appealed. Whereas to the claimant, the effective date of his resignation was 17 February 2020, when he wrote and sent his letter of resignation to the defendant. When, therefore, his effective date of resignation, the settled law is that a resignation letter takes effect from the day it was written and received by the employer. Resignation as a means of bringing an employment to an end was enunciated in Waek versus O'Shea Noble, quoted in 2006, 12 Nigeria Weekly Law Report, part 994, page 258, Court of Appeal, where the court looked at resignation with immediate effect and notice of retirement. In the case of Esowe versus Government of Edo State, quoted in 2001, 13 Nigeria Weekly Law Report, part 731, page 517, the Supreme Court's case, The Supreme Court made it clear that the right of an employee to resign at will is founded on the principle of law that court cannot force an unwilling servant on a master, just as it cannot force an unwilling master on a servant. Therefore, when an employee tenders his resignation letter, it becomes valid and effective the moment it is received by his employer. The Supreme Court went on to hold that since there is absolute power to resign, there is no discretion to reject or refuse to accept a resignation letter. From the above, it is obvious that the resignation of the claimant, which was sent via email to the defendant on the 17th of February 2020, takes effect from that date, and I so hold. It is therefore immaterial whether the defendant instructed him to resign on the 6th of February 2022, or it approved the resignation retroactively on the 6th of February 2022, because it has no power to discern over approved or rejection in a matter of resignation of an employee. As to the claim of the claimant that he was entitled to 765 naira, 765,831 naira, which he tagged money for 11 days of work from 6 February to 17 February 2020, when he tendered his resignation letter. I find this a little bit awkward. Awkward because since the law has vested him with absolute power to resign, by same power comes with responsibility of giving notice or risk his salary in lieu of notice. It is therefore a bit unreasonable on his part to have resigned without notice and yet be the one asking for salary for 11 days. This court, given the circumstances, is not moved to grant any sum in 765,831 days naira to the claimant, because he must and ought to fulfill that entitlement, having resigned his employment without notice, and I so hold. From the above, what the claimant will be entitled to as payment for his terminal benefit is 3,441,000 naira 52 as against 4,206,857 naira 52 kobo, which included the sum of 765,853 naira as money for 7 days' work. The other thorny issue that raised a lot of argument is the issue of the claimant's debts being written off. The argument on this was so please go tell her that I'm important. Sorry. The other thorny issue that raised a lot of arguments is the issue of the claimant's debt being written off. The argument on this was so entrenched in the defendant's dedicated 4 of the issue she formulated in her final written address to this. To the claimant, his indebtedness to the defendant was written off. To buttress this, he relied on Exhibit C14, C18, and C8. He also, now Exhibit C14 is the claimant's statement of account covering February 2020 to May 2021, to which the 5th May 2021, there is a narration that reads, being a write-off of loan balance of Kingsley Esowe. So C18 is an email communication from Damien, a divisional head, remedial asset management of the defendant to the claimant, which he penned Kingsley. How did you come about this write-off without remedial being carried along? Thanks and good morning, Damien. So Exhibit C8 is titled Re-Resignation of Appointments, dated March 13, 2020, and addressed to claimants by the defendants. Attached to it is the end of service at the EOS statement of the claimant tagged as revised 12/3/2020. To the chairman by his revised EOS of 12 March 2020. It is a demonstration that his debts have been written off by the defendant. The claimant also relied on Exhibit C11, which is a mugshot of the balance of his current account number 505500422199 and two other numbers containing his loan accounts. The defendant that she wrote off the indebtedness of the claimant, she even challenged C11, which is the defendant's final address, dwelled on extensively on the matter of writing off claimant's debts. Looking at the facts, evidence and arguments of counsel on this head, it is important to reproduce some of the facts and content of some of the documents in evidence before this honorable court. In paragraph 11 to 18 of the claimant statement of facts, claimant alluded to a meeting of 6 February 2020 held with the representatives of the defendants, to which some of the conditions he gave for his retirement were that the 50% of his annual salary, which the defendant proposed to pay him, should not have any deductions as part of his indebtedness to the defendant. Also, there should be total cancellation of his outstanding debts to the defendant. He was asked to put this in writing, to which he did via email of 6 February 2020. In another meeting of 11 February 2020, Mr. Charles Nwachukwu, the defendant's CHRO, informed him of non-deductions from his entitlement, save his credit card debts, based on statutory regulations, and that the write-off of the debts will be done within 6 months period. This assurance was oral, and there was no documentary evidence in support. Furthermore, the claimant averred that the end of service EOS statement of 13th March 2020, which revised that of 6th March 2020, is a testament that his debts have been written off. I would like to reproduce the content of the cover letter accompanying the end of service statement of 13th March 2020, which was tendered and admitted as Exhibit C. It reads, and I quote, "Re-resignation of appointment. Sequel to your exit from Fidelity Bank, PLC, effective February 6th, 2020, Please find attached the breakdown of your revised end of service statements. You are not, sorry, your net indebtedness to the bank at March 13, 2020 is 22,418,044 naira 64 kobo only. You are expected to have fully repaid this amount within 180 days from the date of the initial letter, following which interest will be charged on the outstanding amount at the bank's current prime lending rates, PLR. Please note that a base rate of interest plus penal interest charge will also apply whenever your operative account is overdrawn. Also, be informed that any other indebtedness expenses incurred during your employment, yet unknown, shall be communicated to you for settlement. We wish you success in your future endeavors. Kindly acknowledge receipt. Thank you. Going by the contents of this cover letter. Sorry. Going by the contents of the cover letter reproduced above, I do not see anyhow the claimant could draw the conclusion that his debts have been written off. Even if Exhibit 8 is juxtaposed with Exhibit C7, the only difference there is that whereas 10 million naira was deducted from the sum due to him as terminal benefit, which reduces debt profile to 13 million odd. Okay. In Exhibit C8, which without Exhibit C7, it's only allowed the payment of 10 million naira to the claimant without deducting same from his debt profile. This then puts his debt profile to be 22,418,044 naira 64 kobo. As for Exhibit C18, which is an email from Mr. Damian to the claimant, he didn't, as a matter of fact, acknowledge or give vent to the writing of the death of the claimant. I've earlier reproduced the contents of the email. From the contents, all I can see is a Mr. Damian wondering aloud the possibility of the deaths of the claimant, a claimer, written off without his own knowledge as the head remedial asset management. I don't know how that translates to a concession or approval of the debts of the claimant to have been written off. Exhibit C11, which is a mugshot from the claimant's phone, does not look anything as a message conveying the writing off of a debt running into millions. Exhibit C14, which is the claimant's bank statement, starting from February 2020 and ending 5th May 2021, has 7 columns: transaction date, value date, channel, details, pay in, pay out, and balance. In the last row of page 3, which is the last page, the transaction is 5th May 2021. Value date is 5th May 2021. Channel is others. Details are being a write-off of loan balance of Kingsley Esowe. Pay in is 17,833,869 naira 31 kobo. Pay out is nil, and balance is 6,413,763 naira 79 kobo. This court takes judicial notice of the fact that pay in means money paid into the account of the recipient. Therefore, the bank paid the claimant the sum of 17,833,869 naira 31 kobo and tagged same as being a write-off of loan balance of Kingsley Esowe. I also noticed that the account of the claimant was in the negative from 23rd March 2020 to 27th April 2021. But all of a sudden, it had a balance of 6,413,769 naira 76 kobo on 5th May 2021. Not being in the negative. For the avoidance of doubt, the balance of the claimant on the 27th day of April 2021 was written in minus as minus 11,420,110 naira 52 kobo as minus what I've just said. How an account which was in debit automatically metamorphosed into an account in credit is something the claimant never explained to the court, except that it means his debits have been written off. Even the amount stated in his indebtedness in Exhibit T8 is in stark contradiction to the 17,833,869 naira 31 kobo paid into the account of the claimant in Exhibit C14 tagged being write-off of loan balance of Mr. Kingsley Esowe. These discrepancies and disparities, the claimant first explained to this honorable court. No fairness to the claimant. The documents he relies on as documents evidencing the writing off of his debt are nothing but conflicting documents. And when the documents are conflicting as the ones tendered by the claimant before the honorable court, it is not the duty of the court to pick and choose which one to believe without a credible explanation from the claimant. See the case of Olufemi Ayorinde versus Chief Ayodele Kufuor-Richi, reported in 2022, LPELR 56600, then SC/27/2008, where the Supreme Court stated this settled principle of law as follows, and I quote, when there are material contradictions in the case of a party, the court cannot, without credible explanation by evidence, pick and choose which piece of evidence not to believe. Boymuka versus State, reported in 1976, 10 Supreme Court 305. Okay, that's where it is. It is not for the court to provide explanation for inconsistencies in a party's case. See Onubog versus State, reported in 1974. 4 UILR 538. That burden falls squarely on the party who fails without explanation in the circumstance, unquote. Now, given the foregoing, the failure of the claimant to explain the discrepancies and the disparities highlighted above are fatal to the case of the claimant, and I so hold. In this light, Exhibit C11 and C14, though admitted in evidence before this honorable court, are documents the court cannot place any weight of evidence on. Therefore, the objection of the defendant is sustained to the extent that the court shall not attach any evidential value to Exhibit C. From a prudential look at the facts and evidence before me, the only conclusion I can draw is that the case herein is a case of claimant who earnestly wanted his indebtedness written off, and a case of the defendant who never had any intention of writing off the debts. If the defendant genuinely intended to write off the debts of the claimant, he would have used a formal channel to communicate them to the claimant. Unfortunately, because she had no such intention, writing off the debts of the claimant, it left the claimant with no choice but to start seeing in every form and image the writing off of his debts. And unlike the vision of a man in a trance, this image started looking like reality to him. However, whenever he wakes up to reality, he always discovers the obvious. Be it as it may, the court as a court of law and justice and equity is not a cause that can be moved or drawn into a trance or a land of mirage. The court can only dwell in the land of reality, surrounded by cold facts and solid evidence. Therefore, in the absence of cold facts and solid evidence, the court cannot be moved into believing that the defendant wrote off the debts of the claimant. In all, the claim of the claimant on his debts being written off is bound to fall on want of evidence, and I so hold.
As the court, please.
Issue number 2, that is whether the defendant counter-claimant has proved his case is entitled to the relief sought. A counterclaim, even though filed along a substantive case, is distinct from the substantive case and must fail or succeed independently on the evidence adduced in support of same. The counter of the defendant counterclaimant is majorly on the debts owed by the claimant. It is not in dispute that the claimant is indebted to the defendant. However, what is in dispute is whether the debts owed the defendant by the claimant have not been written off. The issue of whether the debts have been written off was addressed extensively in issue 2, in issue 1. Therefore, there won't be need for further repetition. However, that does not excuse the defendant counterclaimant from leading evidence specifically on how to arrive at the amount she now claims that the claimant owes her. This is so because the head of the claim of the claimant, which is on debts owed her by the claimant, falls under special claims. And like every other special claims, it must be specifically pleaded and proved. See the case of IHABUHMB versus Anyip, reported in 2011, 12 Nigeria Weekly Law Report. Part 1260, page 1. It's a Supreme Court case where the Supreme Court made it clear that unless pleaded and strictly proved, the court is not obliged to make any award on special damages. Therefore, if the defendant's counterclaimant hearing is desirous of moving the court into granting her claim, touching on a debt which she claims to be in the tune of 34,987 naira 1,182 naira 57 kobo. Then it should be ready and willing enough to evidence on specific proof of same. In the case before me, there is no scintilla of evidence from the defendant touching on offer and acceptance of the loan, nor is there any loan agreement before me outlining the terms and conditions of the loan in issue. Even with regards to the title document of the claimant in the hands of the defendant, there is no deed or mortgage before me, nor is there any document shown to this court to evidence how the title documents of the claimant pass from the claimant to the defendant. All that the defendant succeeded in doing is to plead facts that the court, to plead facts before the court and leave the court to either speculate or source for the evidence herself. Be it as it may, the duty of the court has never been to speculate on evidence, no, not before it. In the case of Stephen Idubwe and Sons Limited versus Aneni, reported in 2003, FWLR, part 149, page 1418 at 1437, paragraph H to A. The court held as follows, quote, in the absence of evidence, the court is not open to speculate on what is not before it, as court of law considers only cold facts as evidence for it, and not fictions of imaginary evidence. The rule is that the court has nothing to do with what is not before it. A court of law is not a charitable institution. His duty in litigation is to render unto everyone according to his proven claim. Furthermore, when a party fails to lead evidence in support of his pleadings, the presumption is that he has abandoned the same, and he shall be deemed to have so done. Therefore, in the hearing, the court, in the absence of evidence, that is touching on the debt sum that the claimant owes the defendant, is moved to dismiss the counterclaim of the defendant, and I so do. Consequently, as the counterclaim of the defendant fails and same is hereby dismissed, for the purpose of the findings of the court, while resolving issues, resolving issue 1 distilled by the court, the claim of the claimant proceeds as follows. Relief number 1 fails. Relief 2 succeeds, only to the extent that the defendant shall pay the claimant the sum of 3,441,026 naira 52 kobo, representing the shortfall of his terminal benefit, calculated to be 50% of his annual gross salary. Relief number 3 fails, For there is no evidence touching on the specifics of the loan agreement leading to the transfer of the title documents of the claimants to the defendants. Relief number 4 succeeds only to the extent highlighted in relief number 2 above. As for pre or post judgment interest sum, the court is not moved to grant any, given the facts and circumstances of this case. Relief number 5 fails. Relief number 6 fails. Relief 7 fails. Given the facts and circumstances of this case, this court is not moved to grant any sum as costs. Rather, parties shall bear their respective costs. And that is the judgment of the court, and it is entered accordingly.
As the court, please.
As the court pleases.
All this person. All about it.
The erudite ruling, judgment of this court. One more time, the court has proved that the common man and the common bank can have solace in justice in this honorable court. My Lord, this is a beautiful Christmas. We are most grateful, and we wish my Lord a wonderful Christmas.
Thank you, and I wish you the same, honestly.
Thank you, my Lord.
My Lord, in the same manner, I want to thank the court most sincerely for the industry put in this judgment. I can only wish my Lord the best, and a Merry Christmas in advance. I'm grateful, sir.
Thank you very much. I wish you the same too. May God bless us all.
Amen.
Okay.
Amen.
All right.
Thank you, my Lord.
All right. Asking you what?